So we're moving on to the series to the types of probates. This is video 2, probate with a will. A deceased person with a will is known as a testator. When a testator dies, the executor is responsible for initiating the probate process with the court. Basically, you're filing a form. Estates can have different rules from the timeline in which each will must be filed after death. Filing a will is just starting the probate process, basically. The probate process is a court-supervised proceeding in which the authenticity of the will is proven to be valid and accepted as truly the last testament of the deceased. The court officially appoints executor, who is already named in the will, and gives him full legal authority to act on the behalf of the deceased. A will typically designates this legal representative. If not, then the court will appoint one. This person is responsible for locating and overseeing all of the assets of the deceased. The person, the executor, has to estimate the value of the estate by using either the date of the death value or a proper evaluation following the IRS codes. Most assets that are subject to the probate administration come under the supervision of the probate court in the county where the person lived at the time of death. The exception is real estate. So for that, probate land relies on the county and the state where the real estate with the property is located. The executor also has to pay any debt, any taxes by the deceased. So, for a list of documents that you will need to collect, please again refer to the book, which is the Comprehensive Guide to Financial Matters After Death. Reach out to get a free copy. Creditors usually have a limited amount of time. It tends to be about a year from the day of the death to make any claims against the state for any money that is owed. Claims that are rejected by the executor can be taken to court, where a probate judge will decide the final say on whether or not the claim is justified. The executor is also responsible for filing the last personal income tax return on behalf of the deceased. Any state taxes that are pending can also come due within 1 year from the day of the death. So after the inventory of the state has been taken into account, the value of the assets have been calculated, and all of the debt has been paid, the executor then will ask for authorization from the court to distribute whatever is left on the estate to the beneficiaries. If the deceased person's estate is insolvent, which means that they have more debt than assets, then we more likely won't have to initiate probate. In general, this type of individual estates may have their own ruling and have to follow different thresholds. Trust funds can be orchestrated to pass immediately to designate inheritors upon death. We have different types of trust that can help us with this.